The Supreme Court of the Philippines. Composition: a Chief Justice and 14 Associate Justices. 2. May sit en banc or in divisions of 3, 5, or 7 members. C. Vacancy shall be filed within 90 days from the occurrence thereof. D. Strict composition. There is but one Supreme Court whose membership appointments are permanent, from the case of Vargas versus Rasa, 1948. How many divisions can it have? If 2 divisions, 7 members. Kung 3 divisions, 5 members. If 5 divisions, 3 members. Note, they have full discretion on the number of divisions. Right now, they sit in 3 divisions. Okay. En banc and division cases. En banc cases are cases decided with the concurrence of a majority of the members who actually took part in the deliberations and voted. Instances when the Supreme Court sits en banc. 1. Those involving the constitutionality, application, or operation of 1. Treaty. 2. Orders. 3. International or executive agreement. 4. Law. 5. Presidential decrees. 6. Instructions. 7. Proclamations. 8. Ordinances. And 9. Other regulations. Second instance, when the Supreme Court sits en banc, the exercise of the power to discipline judges of the lower courts or order their dismissal. Section 11, Article 8. 3. Discipline of judges can be done by division, but en banc decision cases for dismissal, disbarment, suspension for more than 1 year, or fine of more than 10,000 pesos, from the case People versus Gakot, 1995. 4. Cases or matters heard by a division where the required number of votes to decide or resolve these is not met. Section 4, subsection 3, Article 8. 5. Modifying or reversing a doctrine or principle of law laid down by the court in a decision rendered en banc or in division. Section 4, subsection 3, Article 8. 6. Actions instituted by citizens that test the validity of a proclamation of martial law or suspension of the privilege of the writ. Section 18, Article 7. 7. When sitting as Presidential Electoral Tribunal. Section 4, subsection 7, Article 7. 8. All other cases which under the rules of court are required to be heard by the Supreme Court en banc. Section 4, subsection 2, Article 8. Requirements and procedures in divisions. 1. Cases decided with the concurrence of a majority of the members who actually took part in the deliberations and voted. 2. In no case without the concurrence of at least 3 of such members. 3. When a required number is not obtained, the case shall be decided en banc. Example: cases versus matters. Only cases are referred to en banc for decision when required votes are not obtained. Second example: cases are of first instance. Matters are those after the first instance. Example: motion for reconsiderations and post-decision motions. And third, failure to resolve a motion because of a tie does not leave the case undecided. Motion for reconsideration is merely lost, from the case Fortrich versus Corona, 1998. The Supreme Court en banc is not an appellate court vis-a-vis its divisions. The only constraint is that any doctrine or principle of law laid down by the court, either rendered en banc or in division, may be overturned or reversed only by the court sitting en banc. From the case PUP versus Firestone Ceramics, 2001. There is but one Supreme Court of the Philippine Islands. It is the jurisdiction of the Supreme Court which cannot be diminished. The Supreme Court remains a unit notwithstanding its works in divisions. Although it may have two divisions, but it is a single court. Actions considered in any of these divisions and decisions rendered therein are in effect in the same tribunal. The two divisions of this court are not to be considered as two separate and distinct courts, but as divisions of one and the same court. From the case U.S. versus Limsionko, 1920. Powers and functions of the Supreme Court. Procedural rulemaking. From Section 5, Article 8, the Supreme Court shall have the following powers: promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and the legal assistance to the underprivileged. The 1987 Constitution took away the power of the Congress to repeal, alter, or supplement rules concerning pleading, practice, and procedure. The power to promulgate rules of pleading, practice, and procedure is no longer shared by the court with Congress, more so with the executive. From the case Echegaray versus Secretary of Justice, 1999. Limitations of the rulemaking power. 1. Shall provide for a simplified and inexpensive procedure for speedy disposition of cases. 2. Uniform for all courts in the same grade. 3. Shall not diminish, increase, or modify substantive rights. Administrative supervision over lower courts. Second function, function of power and function of the Supreme Court. Administrative supervision over lower courts. Administrative powers of the Supreme Court. 1. Assign temporarily judges of lower courts to other stations as public interest may require. 2. Shall not exceed 6 months without the consent of the judge concerned. 3. Order a change of venue or place of trial to avoid a miscarriage of justice. 4. Appoint all officials and employees of the judiciary in accordance with the civil service law. 5. Supervision over all courts and the personnel thereof. 6. Discipline judges of lower courts or order their dismissal. Note: the qualifications of judges of lower courts are stated by the Constitution are minimum requirements. The Judicial and Bar Council may determine or add more qualifications when such policies are necessary and incidental to the function conferred in the Constitution. From the case Villanueva versus JBC, 2015. What are the periods for deciding cases? Section 5, subsection 1, Article 8. Supreme Court can decide cases within 24 months. Lower collegiate courts, 12 months, unless reduced by the Supreme Court. Other lower courts, 3 months unless reduced by the Supreme Court. Note: 1. Period is counted from the date of submission. 2. Case deemed submitted upon filing of the last pleading, brief, memorandum, or memorandum required by the rules or the court. Section 15, subsection 2, Article 8. Upon the expiration of the period, the Chief Justice or presiding judge shall issue a certification stating why the decision or resolution has not been rendered within the period. Section 15, subsection 3, Article 8. This provision is merely directory, and failure to decide on time would not deprive the corresponding courts of jurisdiction or render their decisions invalid. From the case De Roma versus CA, 1987. The failure to decide cases within the 90-day period required by law constitutes a ground for administrative liability against the defaulting judge. People versus Mendoza, 2001. The Sandigan Bayan, while other same level as the Court of Appeals, functions as a trial court. Therefore, the period for deciding cases, which applies to the Sandigan Bayan, is the 3-month period, not the 12-month period. INRE, Problems of Delays in Cases Before the Sandigan Bayan, Admin Matters, 2001. Original and appellate jurisdiction. Jurisdiction is the authority to hear and decide a case. From the case U.S. versus Limsyonko, 1920. Original jurisdiction of the Supreme Court, Section 5, Subsection 1, Article 8, 1. Cases affecting ambassadors, other public ministers, and consuls. 2. Petitions for certiorari. 3. Petition for prohibition. 4. Petition for mandamus. 5. Petition for quo warranto. 6. Petition for habeas corpus. Note: original jurisdiction also extends the writs of amparo, habeas data, and the environment writ of kalikasan. The Supreme Court's original jurisdiction to issue writs of certiorari, as well as prohibition, mandamus, quo warranto, habeas corpus, and injunction is not exclusive. Its jurisdiction is concurrent with the CA and with the RTC in proper cases. From the case of Cruz versus Judge Chingoyon, 2011. Appellate jurisdiction of the Supreme Court. Section 5, Subsection 2, Article 8, on appeal or certiorari, as the rules of court provide, the Supreme Court may review, revise, reverse, modify, or affirm final judgment or orders of the lower courts in 1. Cases involving constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation, except in circumstances where the court believes that resolving the issue of the constitutionality of a law or regulation at the first instance is the paramount importance and immediately affects the social, economic, and moral well-being of the people. From the case Moldex Realty versus HLURB, 2007. 2. Appellate jurisdiction. Cases involving the legality of any tax, imposed assessment, or toll, or any penalty imposed in relation thereto. 3. Cases in which the jurisdiction of any lower court is in issue. 4. Criminal cases where the penalty imposed is reclusion perpetua or higher. 5. Cases where only one question of law is involved. Note: a party who has not appealed from a decision may not obtain any affirmative relief from the appellate court other than what they had obtained from the lower court, if any, whose decision is brought up on appeal. From the case The Abay versus Coca-Cola Bottlers, 2013. Doctrine of Judicial Stability or Non-Interference. Ano sa man siyang doctrine? The court can interfere by injunction with the judgments or orders of another court or concurrent jurisdiction having the power to grant the relief sought by injunction. The rationale for the rule is founded on the concept of jurisdiction. A court that acquires jurisdiction over the case and renders judgment therein has jurisdiction over its judgment, to the exclusion of all other coordinate courts, for its execution and over all its incidents, and to control in the furtherance of justice the conduct of ministerial officers acting in connection with this judgment. From the case United Alloy Philippines versus UCPB, 2015. Finality of judgments. A decision that has acquired finality becomes immutable and unalterable and may no longer be modified in any respect, even if the modification is meant to correct erroneous conclusions of fact or law, and whether it was made by the court that rendered it or by the highest court of the land. From the case Henato versus Viola, 2010. Exception. 1. Correction of clerical error. 2. Nunc pro tunc entries which cause no prejudice to any party. 3. Void judgments. 4. Whenever circumstances transpire after the finality of the decision rendering its execution unjust and inequitable. Note: finality of judgment means that while the court loses jurisdiction to amend, alter, and modify the decision, it does not lose its power over the case with respect to enforcement and execution. The court can suspend the enforcement of a sentence. Presidential reprieve does not preclude the court over the enforcement of decisions after finality. This is in the court's exercise of its judicial power. From the case Echegaray versus Secretary of Justice, 1999.